I've got the microphone here, but I wasn't sure if I needed to move it to more over there. If most of the talking is going to be from
Okay,
here.
I'm going to take this off the top, right? So you can hear better.
I don't know.
Make sure we're all on the same page. Grab your turn.
That's the only way for y'all to hear is from there?
No, I mean, like, this microphone still picks up people that are going to be talking over here. We usually put it here for the commission meetings because
That's what.
people
Yeah,
usually
I couldn't
speak.
hear any of the commissioners on the
Yeah,
last
so why don't you put it, and then if somebody shows up, or you can set it up here, and if somebody shows
Yeah,
up.
what time is it?
Well, you're sitting
then
there.
we'll move.
It's only 2 minutes.
That'd be right between us.
Okay, I'll just kind of hook it right here then.
Oh, this chair is so short. Can I move these, or are these set for the commissioners?
I think whatever you're comfortable with.
I'll move them back.
Just make yourself at home, you're in charge today.
Remember it. Just kidding. Don't want to learn that the hard way.
Not yet.
No, do you want me to turn it on, or is it going to make feedback? Does that make a problem? Can you hear that better?
No, that's good because it's gonna. Our microphone, the camera's gonna pick up better.
Okay. It's 10:30, so I think we can go ahead and start. Good morning. I'm Carrie Blanton with the Alabama Department of Environmental Management. I'm the designated hearing officer for this hearing. I would like to welcome each of you to the hearing today. The subject of this hearing is the proposed revisions to ADEM Administrative Code, Division 335-13. Notice of the date, time, place, and purpose of this hearing was published in the Birmingham News, the Huntsville Times, the Mobile Press Register, and the Montgomery Advertiser on May 3, 2020. Copies of the certifications of these publications are submitted for the hearing record as Exhibits C1 through C4. On May 8, 2020, the Department also caused the same notice to be sent to 2,253 individuals and organizations requesting advance notice of rulemaking. A listing of the individuals and organizations notified will be entered into the hearing record as Exhibit C5. One original copy of the proposed rules was filed with the Administrative Procedure Division of the Legislative Services Agency, and 10 copies were furnished to the Joint Committee on Administrative Regulation Review on March 20, 2020. A copy of the notice was also published in the Alabama Administrative Monthly, Volume 38, Issue 6, on June 30, 2020. These facts are attested to by Othni Lathram, Director of the Legislative Services Agency, by affidavit, which is submitted for the hearing record as Exhibit C6. Copies of the proposed rules have been available for inspection by the public at ADEM field offices in Birmingham, Mobile, and Decatur, and ADEM offices in Montgomery. The proposed regulation changes have also been available on the ADEM internet site at adem.alabama.gov. A copy of the proposed rules is submitted for the hearing record as Exhibit B1. A copy of the summary of reasons supporting adoption of rules is submitted for the hearing record as Exhibit B2. The department has given public notice of these rulemaking proceedings. To date, one written comment has been received. This hearing is being conducted to provide the public an opportunity to present data, views, questions, and arguments on the proposed rules. It is open to the public, and anyone wishing to present oral testimony or a written statement may do so. Persons who have not previously advised the hearing officer of their intent to give oral testimony should complete a registration card and present it to the representative at the registration table. All verbal and written comments received today and during the public notice period will become part of the hearing record. The information in the record will be used in evaluating the proposed rules. Lengthy statements containing considerable technical or other significant data should be submitted for the record in writing. Summaries of such statements may be presented orally. All testimony and written statements should be as factual as possible and should address the subject of this hearing. This hearing is not intended as a question and answer session, and persons giving testimony will not be subject to questioning by the public. They may, however, be questioned by the hearing officer or any other representative of the Department of Environmental Management to clarify points and to develop a better understanding of the information being presented. We will now proceed to the principal purpose of today's hearing, the receipt of public comments. I would ask that each person making a statement please step to the podium, state your name, and any interest or organization that you represent. This hearing is being recorded by a court reporter, and a transcript will be included in the public record. The order of appearances of persons giving oral testimony will be as follows. First, a representative of the Department of Environmental Management, then public officials, then members of the public in the order they filed registration cards to give oral testimony. I now call on Scott Story, Chief of the Solid Waste Branch of the Land Division.
Good morning. My name is Scott Story, and I am the Chief of the Solid Waste Branch of the Land Division of the Alabama Department of Environmental Management. I'm going to provide a brief summary of the reasons supporting the proposed modifications to the ADEM Administrative Code Division 13 regulations. Under the provisions of the Alabama Environmental Management Act 22-22A, Code of Alabama, 1975, as amended, the Department of Environmental Management was given the authority to adopt rules, regulations, and standards in order to carry out the provisions and intent of this chapter. This chapter also provides for the authority to recover the reasonable anticipated cost to be incurred related to the issuance, reissuance, modification, or denial of any permit, license, certification, or variance. Such costs include, but are not limited to, the examination and processing of applications, plans, specifications, or any other data, any necessary public hearings and investigations. The Administrative Procedures Act, Section 41-22-4, requires each agency to adopt rules of practice setting forth the nature and requirements of all formal and informal procedures available, including a description of all forms and instructions used by the agency. In accordance with the Environmental Management Act, the Department is revising the ADEM Administrative Code Division 13 regulations to include changes to Chapter 335-13-15, Standards for the Disposal of Coal Combustion Residuals in Landfills and Surface Impoundments. The proposed revisions to the chapter include updating the state CCR regulations to reflect modifications and clarifications that have occurred in the federal CCR program since the original adoption of ADEM's Chapter 335-13-15 regulations. These regulations provide the Department with the regulatory authority to resolve issues related to the management of coal combustion residuals generated from the combustion of coal at electric utilities and independent power producers. The purpose of today's hearing is to provide an opportunity to receive public comment regarding the modification as noted. The department welcomes your input into this process and will consider all technical comments prior to making a final decision concerning the modification of these regulations. The department will also provide a written response to each commenter and to those requesting specific notice of our decision. Thank you.
Thank you. I will now call on public officials, followed by members of the public in the order in which they filed registration cards to give oral testimony. I would ask that each person making a statement please step to the podium, state your name, and any interest or organization that you represent. And the first registration card I have is for Keith Johnston. If you would like to please come speak.
Let's take this off. Good morning, and thank you for allowing me to make comments today. I'm Keith Johnston. I'm managing attorney of the Southern Environmental Law Center in our Birmingham office, and I want to start by just revisiting the initial promulgation of these rules in 2018. So we were here in 2018 commenting on the same state CCR program, the Coal Combustion Residual Program. And we encouraged ADEM not to adopt EPA's proposed flexibilities at that time to the 2015 federal CCR rule. And ADEM went ahead and adopted most, if not all, of those flexibilities. We now know through the courts and EPA's own failed attempts to roll back on these rules in certain instances that these flexibilities indeed weakened the 2015 CCR rule. As a result, ADEM is now walking back on the state CCR program to match that at the federal level in an attempt, I assume, to eventually receive EPA approval of the state program. I think it's worthy to note that if ADEM would have made their state permitting program more protective of human health and the environment than the federal rules in the first place, that we wouldn't be here having to make these revisions today. As for the proposed revisions that ADEM is now making, we appreciate them removing the less protective provisions from the current CCR program. Examples of this include dropping the provisions that allow a showing of a remediation of release is not necessary, dropping provisions of alternative monitoring frequency allowances, dropping the provision that allowed a showing that there are no practically achievable remedies, dropping the provision that allowed an alternative length of time to show compliance with groundwater protection standards. All those are certainly improvements to the program that are being signaled by EPA or the courts themselves when these provisions were challenged. We know that for ADEM to get approval of this state permitting program by EPA, that you have to drop those provisions because the program is weaker than the federal program as presented currently. But with these improvements, I think, to the state permitting program, we do have some suggestions. And one is that that ADEM not allow utilities a loophole for avoiding groundwater monitoring requirements. In particular, this is 335-13-15.061H. We don't think that should be included under the state CCR rules. This provision gives ADEM the discretion to suspend groundwater monitoring requirements for up to 10 years at the CCR facilities with proper shielding. You know, it's been proven, and ADEM is well aware of this, that these units leak and leach contaminants into the groundwater. And this is at not just one of these CCR impoundments, it's at every CCR impoundment. This has been cited by ADEM in your own administrative orders and for violations under the Alabama Water Pollution Control Act. So groundwater is an integral piece to this whole state program, and it's one of the key reasons that we're trying to clean up these CCR disposal sites today. Also, we were particularly confused why ADEM is removing boron from the Appendix 4 list of contaminants. Originally, ADEM had included boron on that Appendix 4 for monitoring requirements. And the proposal now is to remove it from that list. There's no reason to remove it. I think last time in comments, we had made similar comments in 2018, and ADEM stated that the department agrees that boron should be added to the Appendix 4 so that it is included in assessment monitoring. Therefore, final regulations have been modified to include boron in Appendix 4. And that's a direct quote from the response to ADEM's comments. So we're just curious why now ADEM is dropping that chemical from Appendix 4. Also, we would request that ADEM would remove the provision that allows approval of alternative groundwater measures for purposes of location restrictions. Currently, the location restrictions require a very specific schedule and frequency for operators to measure groundwater for purposes of the regulations location restriction requirements. ADEM is adding to this provision, or as, quote, or as otherwise approved by the department. It's not clear what ADEM is getting at here, but our concern is that ADEM would allow less groundwater protection measures than currently required. And that would allow backsliding on the part of the owners of these CCR facilities. So we think there needs to be some sort of language in there that will not allow backsliding in that instance. I think this is also an opportunity to improve upon the rules. Under 335-13-1506-.06 5A2, in the groundwater monitoring and corrective action provisions, ADEM proposes to allow alternative parameters for detection monitoring. These parameters found in Appendix 3 were chosen for detection monitoring because of their ability to detect groundwater contamination early. The 2015 federal CCR rule states that at a minimum, a detection monitoring program must include monitoring for all constituents listed in Appendix 3 of this part. From the language as the rules are written now, it's unclear if ADEM means that the utilities may monitor for constituents in addition to those listed under Appendix 3, or if the owner or operator may monitor for alternative constituents and therefore not test for those listed in Appendix 3. We would appreciate it if ADEM would take that under consideration in that thought. There's also opportunities here to strengthen the rules. There's currently a mine fill exemption that would allow coal ash to be placed in abandoned mines. With the known groundwater contamination that takes place at these sites, we think that would be a real problem if that started to be a common practice. There's also the exemption for inactive surface impoundments that are exempted from the rules. And so we think that, and there's litigation going on about this now, but we think that those surface impoundments should be exempted from the current rules. And stepping back, just taking a larger perspective, since the last time we were here in 2018, Alabama is becoming the outliner compared to other southern states in the treatment of these CCR landfills and impoundments. Since the state regulations were promulgated in 2018, state legislatures and regulators are taking action to stop coal ash pollution. They're not being more lenient in their rules or regulations or what they're requiring of the utilities. They're being more stringent. Specifically, the states are requiring, or utilities have agreed to implement on their own, the excavation of coal ash impoundments to lined upland modern landfills that are worlds away from the current pits that these contaminants are contained in. Virginia has passed legislation requiring all coal ash to be excavated and either recycled or disposed in a lined landfill. North Carolina's own Department of Environmental Quality has concluded that excavation of all remaining unexcavated sites is the only closure option that could meet the requirements of state law to protect human health and the environment. And the North Carolina Department of Environmental Quality therefore ordered a utility to excavate its coal ash at all 6 remaining sites that they hadn't excavated yet, and that was Duke Energy. South Carolina utilities have agreed to excavate and remove all of its coal ash to upland landfills. In addition to complete excavation in Virginia, North Carolina, and South Carolina, excavation of several impoundments is planned in Georgia and Tennessee. So in Georgia, Georgia Power, Alabama Power's sister utility, has announced plans to excavate 19 of its 29 impoundments. Many of those, it's coastal impoundments. TVA in Tennessee has agreed to excavate coal ash at Allen and Gallatin plants. So there's nothing to stop ADEM from requiring the same of these poorly located coal ash impoundments. And there's nothing to stop ADEM from creating a stronger and more robust CCR permitting program than we currently have today. And we would encourage the agency to continue to consider what's happening in other states, what other state agencies and legislatures are doing on this issue, and following what the science is showing us. And that's showing us that for historical reasons, these coal ash impoundments and landfills were put in some of the worst places possible. We have that same problem in this state, and those particularly bad CCR landfills and impoundments need to be moved to a modern lined landfill. That's it for my comments, and I'm happy to take any questions if you guys have.
Thank you.
Thank you.
I have not received any more registration cards. Is there anyone else at this time who has not had a chance to complete a card who wishes to speak? Let the record reflect that there is no response. The final hearing record will include a transcript of this hearing, all written submissions and exhibits, and a response by the department to each relevant comment received by the hearing officer before 5 p.m. today, Thursday, June 25th, 2020, at the ADEM offices in Montgomery. After consideration of all oral and written comments, ADEM will make a determination regarding possible revisions to the proposed rules and prepare a response to all relevant comments received. When a final decision has been made, ADEM will forward the final draft of the proposed rules as may be revised, the hearing record, and if conflicting views are submitted, a concise statement of the principal reasons for and against adoption of the proposed rules, and the reasons for overruling any considerations urged against their adoption to the Environmental Management Commission for its consideration and possible adoption. Once complete, this record will be available for public inspection in the office of the Department of Environmental Management in Montgomery. Thank you for your attendance and participation today. This hearing is adjourned.